I am heartened to hear that you attended the New York University of Law and are well acquainted with the American judicial traditions, and that your reputation of being one who upholds the rule of law, particularly as it relates to the judicial process, is internationally recognized. I say this, alas, because my experience with the judicial system here in Israel has been upside down at best. As perhaps the leading judicial expert in the country who has both practiced and taught law, you know full well the solemn nature of a motion to recuse the judge. Once a motion to recuse the judge is legally filed, it should trigger a chain of judicial events, first of which is to stop the legal proceedings until the judge who is overseeing those proceedings issues a ruling on the motion to recuse, granting the request or denying it. A ruling from the judge is then either accepted by the party filing the motion, or it is then appealed to the appellate court, in this case the Supreme Court. The laws in Israel regulating judicial conduct are quite clear, providing guidance in matters of recusal and other rules expected by judges to follow. The judicial rules clearly never anticipated that a judge would refuse to rule on a motion to recuse himself, as is the situation in this matter. Your Honor, Professor Yaakov Neiman, it is unheard of, and I have been unable to find in judicial history a case where a judge refuses to rule on a motion to recuse. This truly is one for the historians to ponder over, and is still a work in progress. Your work in progress, I may add. The above matter is enough to disqualify the judge's rulings and verdict, since those came much after the motion for recusal and the evidence supporting the accusations of willful judicial misconduct warrant an investigation. Beyond said matters, there are other motions which are basic to a fair process that have also been ignored by the judge, such as refusing to rule on a motion to disclose evidence to substantiate the damaging and false allegations made by the respondent, refusing to rule on a motion to sanction the respondent for lying in court and filing a false declaration, which is a felony and is not protected by any immunity. It is signed under penalty of perjury, and it is perjury. The facts in this matter of which I complain are demonstrable with hard evidence of the finest quality coming from the mouth of the judge himself, Judge Noam Sólberg. His rulings and omissions, such as failures to rule on motions wherein the plaintiff is entitled to a decision up or down, which is necessary for an appeal with the high court, and the essential for fair process in the district court. Judge Noam Sólberg, the man that you have named to be the successor of Mezuz to become the state comptroller, is the judge in this matter, and would be a disaster for justice and the rule of law if he were to be named essentially the highest law enforcement officer policing the government, when I can prove that he has allowed the government interior ministry and the police to file perjured affidavits, and when told about it, his eye became blind and his ears became stopped. These allegations warrant a full review, and it is not only the integrity of the judge, the legal system, and the rule of law which are on trial, but the integrity of your honor and the honor of the office which you occupy are still on the line, and will be defined by the ability to adjudicate this matter, which will take courage. This will test your ability to look at the facts without any fear of partiality and uphold the rule of law, which I trust that you will. I also possess recorded audio files of the trial which have not yet been transcribed, which prove that under standing objection to remove his lawyer and stop the proceedings, the judge ignored Yusuf's demand to represent himself, which was forced upon him by the judge, who said that he refused to read any of Yomtov's filings or motions so long as he had a lawyer. Yomtov then filed with the judge, removing his lawyer again, and the judge responded to some motions, but never to the most significant motions, such as mentioned in this document, as well as several other pre- and post-trial motions. Judge Noam Solberg has done unbelievable willful acts throughout that can only be described as a travesty of justice at best. 1. The judge in his first protocol wrote untruths, framing the case against Yusuf inaccurately by stating in his official protocol that, quote, the plaintiff provided no documents proving his claims, end quote. This is false. Yusuf brought over a dozen documents of the highest quality, most from official government sources. The truth is, the respondent did not bring one document to support the slanderous lies leveled in court against Yusuf Yomtov with the full backing and consent of Judge Noam Solberg. The judge refuses to rule on motions to recuse himself. The worst injustice, and maybe a first for judicial historians, that is, the judge not only refused to rule on 3 separate motions to recuse himself, but worse, issued a response from the court saying, quote, he is not refusing to rule on the motion to recuse, end quote. Then immediately he issues a rushed verdict without ever ruling on motions to recuse. A motion to recuse the judge is of the most solemn kind, and all the court proceedings must be stopped until the judge rules up or down on a motion to recuse himself. There is not an option to ignore such a motion, yet the judge did worse. After ignoring the motion to recuse for months and continuing the court process, he finally responded to the third motion to recuse himself with an untrue ruling by saying, quote, he is not refusing to rule on the motion, end quote, and then refused by never ruling. This is the worst kind of injustice when the judge himself will obscure the truth, what should be clear, with official words and rulings that conflict with his actions. 3. The judge has turned a blind eye to perjury in his courtroom by the respondent and has allowed such lies to dominate his courtroom even after he is faced with a motion to sanction a respondent and to refer the matter to the Justice Department for obstruction of justice. Instead, the judge never ruled on 2 motions to sanction the respondent, and rather shockingly accepted their perjured declarations filed with the court and lying statements in court, ultimately denying Yusuf Yomtov even an appearance of a fair judicial process. 4. I am being refused access to the Supreme Court. My legal and timely appeal to the Supreme Court was rejected by the employee whose position it is to be the, quote, gatekeeper of the court, Mr. Danny Ben-Tovim. I am required to go through him since I am not a lawyer, and yet he has damaged my case and is wrong in his knowledge of what he claims is, quote, regulations, end quote. His actions are not legal, and he prevented Yusuf Yomtov from filing an appeal against Judge Noam Solberg's refusal to rule on recusing himself and preventing a verdict. Now, due to the employee of the Supreme Court, my case has been permanently damaged in the lower and higher court. I have written a letter to the President of the Supreme Court, and it is attached along with other documents. Dear Professor Honorable Yaakov Neiman, you have inherited a real mess here, and it will take more than gloves to clean it up. A. You have a judge that is making judicial history by being the first ever to ignore repeated motions to recuse himself while continuing the court process. B. You have a judge allowing, relying upon, and protecting lies and felonious affidavits in his courtroom under standing objection. C. You have a Supreme Court that is denying appeal access to the court for Mr. Yomtov so long as he has no lawyer. This is unheard of even in a banana republic. The court records in their totality, along with the recorded evidence, should obviously be examined to determine the scope and breadth of these proceedings, of which can only be described as not fair or impartial, and it does not take a legal scholar such as yourself to know rumors and lies should never even be given a forum in a court of law. And yet the court record clearly reflects that the entire evidence presented and accepted by the judge is exactly that, lies and rumors which are not substantiated by a shred of evidence. Everything I allege did happen and should not have happened in any case, no matter how trivial it may be, since the rule of law and a fair legal process is not trivial. Yet this matter is made more severe when you look into the content of this case, which affects every Jew alive, born in Israel or not, as well as affecting the very foundations of the state of Israel as declared in the Declaration of a State and the law of return. I, Yosef Yomtov, declare under penalty of perjury that the statements I have made are true to the best of my knowledge.